Well, hello, everybody. This is Greg Maluski here with Retirement Income Source of Southwest Florida, once again coming to you on YouTube here today. And today we're just going to talk about estate planning stuff, okay? The kinds of things that most people, unfortunately, put off until way too late in life. The kind of things people think about only if they have millions of dollars to their name. Well, I'm here today to tell you that as a certified financial professional working in this industry for the last 20 years, I will tell you that unfortunately, that is really a bad idea to just push it off until, late in life, thinking that you don't need to worry about it. All right? And we here at the office, we do financial planning, but we also believe that a good financial plan should also incorporate your estate planning. Okay, and the reason is because when you put together good financial planning, it's a good time to sit down and analyze also what happens when you pass away. A good financial plan doesn't just take into account when you're alive. It also takes into account what happens if one of your loved ones in your immediate family passes away. If you or your wife or, God forbid, even a child passes away. There needs to be provision for the survivors. And so a good financial plan would be remiss not to include good estate planning. So when we talk about estate planning, we're not just merely talking about, how to avoid paying taxes or death taxes on millions of dollars, okay? We're talking about documentation that is needed so that the decisions that are really sometimes difficult to make but are worked through and planned for, so that if one of you passes away, the rest of the family can carry on with the least amount of grief and the least amount of heartache. And so in the discussion today, we're going to talk about wills. We're going to talk about trusts a little bit. We're going to talk about the types of documents that you need when we are planning for the unfortunate early passing, or even if someone becomes what we call mentally incapacitated. And I will share with you a story, okay, about my own family, because I believe this will motivate you. I hope so. I hope this will motivate you, okay, because too many people just put it off. And I've seen it too often, and it even happened in my own family. So this is what really helped motivate me to get into this, space, to work in this space with people, to help people with planning. With my own parents, okay, my own mom and dad did not plan well for their future. And unfortunately, my dad was not a big believer in life insurance. He was not a big believer in even doing proper documentation for the types of things we'll talk about today. And they did not have any power of attorney in place between my mom and dad. They did not have even a written living will. If you've ever heard of it before, there was a Terry Schiavo case here in Florida years ago that involved a lengthy court battle between a husband of a woman named Terry Schiavo who was incapacitated. She was in a coma for months. And the prognosis was not good. Her brain was dead. They were keeping her alive on artificial life support, but probably would never come back. And the parents wanted her to live and be kept alive, but the husband said her wish was not to be kept alive in this fashion, that she would be better off just letting her body expire naturally. So it went to court in Florida here, and it was a big deal. And eventually, the court had to settle this out. Now, the problem with that whole thing was the fact that she never put in writing what her wishes were. She had verbally told her husband these things, but the parents didn't want to believe it. Well, that's a problem. Okay, verbal is not good enough in court. Okay, a verbal is not good enough when you need to prove your intent. So if your intent is to be, terminated naturally or left to die when you're brain dead after a car accident or after some horrible disease, and you don't want to be kept alive artificially indefinitely, at a huge cost and expense to your family, and having them suffer through the whole process, then you need to put your wishes in writing. And so we're going to talk about this today. With my own parents, when my dad got hit by a drunk driver, he was 71 years old in 2005, April 7th of 2005. My dad was hit by a 19-year-old drunk driver who smacked into the back end of my dad's car at a stoplight. I'm coming off the highway on-ramp, or an exit ramp, I'm sorry. And there were 4 cars there. My dad was the first one he hit, but he created a massive pileup of cars that all just got smashed into each other, all the way to the very front car at the stoplight. Doing 42 miles an hour, never hit the brake. Drunk, high as a kite. I don't need to tell you what happened to him, but I will tell you that my dad died within 2 days. In that 2-day process, it was like hell on earth for my family because he did not have anything put in writing. So not only did he not provide well financially for my mom, and I'll come back to that in a second, but he did not have proper documentation. Okay, he didn't have any power of attorney for her to make decisions. He didn't have any medical power of attorney for her to make decisions. He didn't even have a written living will. And the prognosis from the doctors was that if he actually survives this, he's probably going to be a quadriplegic, possibly not able to function really well. If he came out of the 3 days worth of swelling and he survived this, it would actually probably require a lot of care to keep care of him. But the fact was they kept coming to us asking for documentation, and the fact that my dad was married to my mom wasn't good enough. Okay, and I'm here to tell you that today, just because you're married doesn't mean it automatically makes your spouse your decision maker for you. Okay, if you're incapacitated, you will put your family through hell if you don't have the proper documentation. You need to name a power of attorney who can make a decision for you when you can't. If you are unconscious after an accident and somebody else has to make a decision for you, they don't have the power to do that unless you put it in writing, okay? Now, he passed away within 2 days, so it alleviated our need to continue this drama that probably would have ended up in court. But I'm telling you that it was brutal for us to work through these things because we had to scour the house. We had to see if there was anything in writing. We talked about how what he heard about the Terry Schiavo case, and we talked about what he would probably want. So we came to an agreement verbally of what Dad would want, that he would not want to be kept alive artificially indefinitely. But again, that wasn't good enough for the hospital. They're looking for protection from lawsuits and things, so they want to see it in writing. So all that to say, too, that because of that process, I learned the hard way, unfortunately, that people need to be more prepared. And I really want to help you. I want to help people not end up in the same position. So when we're talking about financial planning. We're talking about providing life insurance. If you have a lot of mortgage debt, you need life insurance to cover that until the mortgage is paid off so that somebody isn't straddled with the debt. Okay, my mom ended up having to go through foreclosure and so on, and us kids had to help her out and deal with all this because there was not enough to work with there for my mom's care after my dad passed away. Now, a few of these documents I'm going to specifically name today I hope will help you, and we at Retirement Income Source can help you with this, again, with your financial plan. Okay, I always cover this with people to make sure they have their proper documents. So we're going to talk today about wills and trusts and just cover briefly what they are. Okay, when you do these documents, these are more like what I call a one and done. What's really nice about them is, unlike other financial things you have to take care of, these are things that you can just check off your list and be done with it. And believe me, when you do it, you feel such a sense of relief. The first one is called the last will and testament. Okay, every state in the union uses some form of a last will and testament, and you don't want to die without having one. Okay, the last will and testament is the document for all of the things that don't have beneficiaries on them. legal documents like IRAs and contractual things like that, annuities and things all have beneficiaries, which is great. But for things like cars and jewelry and houses and land and all those sorts of things that have titles to them, you need to have a will in place, your last will and testament in place, so that your family knows who's supposed to get what. Most wills will say, okay, I give all my assets to my wife if she survives me, but what about kids? What about nephews and nieces? What about charities? If you want certain things to go to charity, you can name that in your trust, in your will, and then use that. That document will go through probate court, okay? Now, a will is good for like a big blanket, if you will, that kind of covers everything that doesn't have a beneficiary on it. But as far as other accounts, bank accounts, IRAs, like we talked about, annuities, these kinds of things, brokerage accounts that can have what we call a transfer on death beneficiary, all those things are not subject to your will, okay? Now, I'm not an attorney, so this is not legal advice. However, in my training as a certified financial professional, okay, we learn and we study and we continue to take continuing education, so we are on top of these kinds of things and understanding how they relate to the best financial plans and the best tax strategy to leverage assets properly, okay, and not give away all your money to Uncle Sam in the process, okay? But having things titled properly is key. You use a will for all those things that don't have beneficiaries, though. So all of the accounts that we manage, we make sure we put beneficiaries on as many things as we can so that it doesn't have to be subject to probate court. Anything you put in your will has to go through probate, and it can be challenged by other people in your extended family. That's where the long-lost cousin shows up and like, hey, I haven't seen Uncle Bobby in so long, and all of a sudden he wants a piece of the pie, right? So a lot of people will use a trust as well. Now, when it comes to trust planning, a good trust planning scenario involves not only an estate planning lawyer, but also working with people like us who do financial planning and advisory planning, because it should be worked together to make sure that plan is in good. So we're going to talk today a little bit about things also like charitable remainder trusts and qualified charitable distributions. Now, when you set up a trust, the idea is to avoid probate court, which a trust will do as long as you have successor trustees who will outlive you. But what's nice with trust, too, is it's a good way for you to set up charitable gift. And we specialize in that as well here at Retirement Income Source. We also want to help you think about not only your own family, but what's important to you in relation to other charities in your life, okay? Churches and schools and perhaps other things. I have a client yesterday who was wanting to give a lot of her money to a wildlife organization, okay? To her, that was very important because she doesn't have any children. So you can use trust to do that. Also, with IRA accounts, for example, we help people with charitable distributions, okay, what we call QCDs, qualified charitable distributions, so that they can avoid having to pay taxes on a forced thing called an RMD. Instead of taking your RMD, your required minimum distribution, to yourself, you designate that to a charity so that you get the tax break. Now, these are things that, again, you need to call us and get a consultation, a free consultation. We'll help you figure out what would be in your best interest in that regard. Now, going back to the documents we talked about, when it comes to the planning for someone that comes after you, your survivors that will outlive you potentially, or in the case of, like I say, an early death, you need to have at least 4 primary documents done, and a 5th one would be a trust, okay? First off, the living will, or the living will for your hospital, for your doctor. We're going to talk a little bit about that today. The living will, as people hear about, and as I mentioned earlier when I was talking about Terry Schiavo, okay, that she didn't have one of those, and neither did my dad. We will talk about that a little bit, why you need one. But the living will also requires, when you do a living will, that you have what's called a healthcare surrogate. So when you set up a healthcare surrogate, it's like a medical power of attorney. And then we have what we call a financial power of attorney. So there's 4 of these: last will and testament, the living will, okay, which talks about what happens to you if you're still alive, but you want to tell people how to care for you. The healthcare surrogate, also another version of that is a healthcare proxy, as well as naming a financial power of attorney. Now, we already talked about the last will and testament. So next we're going to talk about the financial power of attorney. Okay, financial power of attorney. Financial power of attorney is also what we call a durable power of attorney. Okay, there are different types of powers of attorney. Most estate planning lawyers that I've talked to agree that a good power of attorney is called a durable power of attorney, because what that means is it's still in force if you are incapacitated and can't talk for yourself. So that is the most important time to have one of these, where you have someone else who can be a decision maker for you for your medical care as well as for your financial matters. Okay, so if you go to the hospital, let's just say like my dad, who was carried to the hospital in an ambulance, and he was almost incoherent at the moment after this accident. So they need you to sign your life away at the hospital, financially taking responsibility for all their care. And if you're not coherent enough, they're going to make you talk to someone else. They're going to make you find somebody who is a power of attorney. A financial power of attorney is going to have to sign the financial responsibility forms for you if you can't do it for yourself. If you're bleeding out in the emergency room, you really need to have somebody that can sign those forms for you. Secondly, you need to have what's called a healthcare surrogate, okay, which is a form of a medical POA, or a medical power of attorney. A healthcare surrogate is someone who can make a medical decision for you. And in the case of my father, who was having all kinds of issues after the car accident that he had, the doctors continue to come to us asking us for answers on different types of medications they can give that will do certain things. Certain things help, but then have side effects. And so the juggling of all that requires somebody to make a medical decision when you can't do it for yourself. That's called a healthcare surrogate. Okay, some states they call it a healthcare proxy. Now, I will also mention that you need to have one of these guys. You need to have one of these healthcare surrogate named so that they can enforce the living will. If you don't have one of these, this is worthless. Okay? You can tell the hospital all day long, sign their medical directive. They also call it an advanced medical directive. You can sign this and say, here's my wishes. I don't want to be sustained artificially, or I do want to be sustained. You can even go so far as to do another thing called a do not resuscitate. Okay, DNR's called a do not resuscitate. That is a decision you need to make ahead of time before something bad happens. Do you want to be resuscitated if you have a heart attack? I do, but some people don't. So you put that in your living will, but this person is the one that actually enforces it. This is the person that goes to the hospital with you and then says, they have one of these, and this is what you need the person to say, hospital, you need to enforce this, okay? They will help make sure this gets honored, this living will. So that is what I have for you today. I wanted you to know these are the 4 primary documents that you need. I'll summarize again: a last will and testament, a financial power of attorney, a medical or healthcare surrogate, and a living will. Okay? 5th would be a trust. If you have assets that you want to give to other people in your family, or if you literally don't trust somebody that's in your immediate family, and unfortunately that happens a lot with families, you name a trust, somebody else as a successor trustee that will outlive you, that will help manage all this for your family after you're gone. We're grateful that we had the opportunity to come to you today with this information. So we just want you to take time and know that if you get these documents taken care of, your family will be well protected and you'll have greater peace of mind knowing that your loved ones are provided for because you took the time to actually take care of all these things. So if you want more information on financial planning, just follow us, subscribe below, and hit the like button there. All right, take care now.